then, my lord, a judicial intervention. And if your lordships can consider waiting till, my lord, the legislation is put in place, your lordships would have the benefit of that legislation also, because many of the concerns of the petitioner may be taken care of.
Malas,
But
may I?
when
May I?
did that happen? Because can we keep on it?
Malas,
Since
2017
was-
was going on for 5 years.
My lord, since it was listed yesterday, very late, my lord, the matters were listed.
It was being heard earlier also.
Yes.
So that was some 2 years, 3 years back.
That's right.
No,
If the legislature was keen to have a legislation, it could have brought the legislation. I mean,
No, there was a,
either we keep on endlessly putting it on.
no, what I'm submitting is
So we
there
have
was
to
a
legislate.
there was a legislation, a new bill was prepared. That new bill, my lord, for good reasons, my lord, is now withdrawn, and another bill is under preparation, my lord. Since the matter came up late night, I could not gather the instructions, what time it will take.
Malas,
That's my answer.
may I, Malas, just respond? I'm appearing for WhatsApp. My learned friend is for Facebook. Malas. Now, Malas, this litigation is not WhatsApp centric. Because if you talk, my learned friend has made it WhatsApp centric. If you talk of privacy policy, it applies across the board to all platforms. Maybe Facebook, maybe Google, Twitter, every platform it will apply. So it has implications not for WhatsApp. It has implications throughout the world on all social platforms. That's number one, Malas. And all intermediaries, it has implications. That's number one. Number two, Malas, the High Court in this matter decided that the writ does not lie. Well, that's an issue that your lordships will decide at the appropriate time. Third, my learned friend talked about the European law. Malas, European law is a unique law applicable to Europe. For the rest of the world, Malas, WhatsApp follows laws of all other jurisdictions in the rest of the world, whether it's Australia, Canada, United States, and Japan. For all those jurisdictions, the present law is applicable. So my learned friend is now saying, because it is discriminatory for Europeans, we should follow the European standard, and we should not follow the US, the Australian, the Canadian, the Japanese standard. Well, that's something that your lordships will have to decide.
Mr. Sibal,
See, our job.
sorry, I'm sorry.
No, go ahead.
Go ahead. Mr. Sibal, are we correct in understanding that you have different standards? Obviously, you have now said so.
Yes.
Indian WhatsApp users are the highest in the world. Is that correct?
That is correct.
Yes.
So, the advantage and disadvantage for the largest group of users is what is perceived here, apart from the maintainability aspect that you have pointed out.
No, the issue is not that, Malas, whether they are the largest user or not.
No.
It will depend on jurisdiction, Malas. The point is, it depends on jurisdiction.
We'll
The
discuss.
point that I'm making is, Malas, it ultimately depends on the law framed by Parliament. If the European Parliament frames the law, Malas, the jurisdictions will have to follow that. If the US Senate frames a law, that will have to be followed. If Australia frames, so what my learned friend is saying to your lordships is the following: that they, and Malas, kindly don't look at it from the point of view of one aspect also, Malas.
No, I'm sure there are many.
Yeah, now kindly look at it from this point of view. This has global repercussions. If we are the largest users,
True.
it has global repercussions.
And
If we are the largest users, it depends on the kind of investment that this country is going to get into. If you have a law that restricts through a judicial determination certain policies, Manas, you may not get the investment. So it has commercial implications, it has investment implications, it has free speech implications, it has privacy implications, and it has implications that we should, now there should be a judicial dicta that we should follow the European law and not laws all over.
One is not saying that, but the
No, but at the
commercial
same time-
exploitation of data.
At the same,
That's right. So Manas, there's a commercial aspect to it. So Manas, there are.
at the same time,
It's not-
if you go through the judgment of the Delhi High Court,
Yes.
direction was given, actually.
Yes.
A direction was given. At page number 15,
Yes.
you can see an order was issued that the users who opt to remain in WhatsApp are concerned. And up to 25/9/2016, that shall not be shared with the.
Yes, we have complied with that. Complied.
So it
We have
cannot be
complied
said
with
that
that.
that was, it cannot be said that that was not entertained or.
No, we've complied.
If it could not have been maintained, where is the question of issuing
No,
such a
that's I'm saying High Court decided. I'm not, Malas,
High Court?
I'm
High
not
Court
saying,
was
Malas, that your lordships will be inhibited by that technicality.
High
I'm
Court
saying
decided.
issues of far-reaching importance.
There are two choices.
Yes.
In the light of the observation made, the submission made by the solicitor. One is to consider posting it in January.
Yes.
Which means this will give the legislature ample time to bring in a law. what are we here trying to, is it establishing a point or securing the rights of the users? Now, if the legislature is going to come forward with a comprehensive law, which may be a solution to all the problems, we need not be breaking our heads to, establish the point in law as such. If there is no likelihood of, if that's, I think, a reasonable time we are giving. We are putting it, say, somewhere in the second week of January. The other is to put it at the earliest, which can be in the second week of November, and proceed to hear the matter.
So may I respond to that? So first and foremost, I don't have a problem if the matter is fixed in the second week of January, but it ought to be, I can only request, it ought to be on the understanding that there will be a final hearing on that particular date. Because it can't be that in January, then we are again for directions just for another 3 months.
Either there is a law, or
either there is a law, yes,
or we will begin hearing.
Yes, because the burden of our song is also until a law, what should be the norm required? No, that is ultimately, because how can we prevent Parliament from, or whoever, whichever the appropriate legislature is, from making a law, and that can always be amended because there will be an element of experimentation. So I have no problem with 15 January, but I will only request that then let it be in 15 January, whatever date or thereabouts, fixed for final hearing. We will file our written arguments before that.
All pleadings
Yes,
to be
yes.
completed, we'll go on with the case.
Yes, I agree.
But my stand is clear. My stand is clear. Howsoever big a multinational is, if you are operating in India, you have to comply with the laws of India, and you have to treat Indian citizens with equal degree of privacy which you are treating others.
That's true.
But the difficulty is, I'm not making it WhatsApp centric. It should be citizen centric.
That's correct.
And no, it's not correct. Many of the directions of the central government are flouted. Many of the legal directions under statutory regime are flouted. Yeah, we are arguing one matter, filed by one intermediary. I'll not name. Mr. Datar is appearing in Karnataka High Court. So, they may not feel that since we have a global presence and we have kind of a...
All right. We learn it.
My lords, I have been the corrected.
My lords,
Mine is a writ petition where pleadings are not complete. It's also a collated issue of data localization, where our private data should be stored within the norms of this country and be made available to regulators and courts as and when called upon for. There's no law to that regard. All the information pertains to us, WhatsApps, whatever, is all being stored outside India. So therefore, the compliance with courts orders and regulators is pure voluntary in nature by them. So my prayer is, my lords, in terms of informational privacy as recognized, my lords, by constituents of this court, the data should be stored in India and made available to regulators.
That's
my lord,
Issue pertains to us.
my lord, we have filed an impediment intervention.
you are here.
Sorry.
We're searching for you. Yes.
Sorry, my lord, we have filed an impediment intervention application that had been accepted by my lords in 2017. So Vishwanathan had appeared on our behalf in my lords will see the orders. We had made detailed arguments.
Who's that?
Mr. Vishwanathan for Internet Freedom Foundation.
Huh?
Internet Freedom Foundation, my lord, it's a digital rights organization. So my lord, we had filed our petition is also on our intervention application is also on record. My lord, we had also filed an application for directions given the 2021 privacy policy. However, despite many times trying to get the matter listed, the matter was never listed. Our IA was never listed. If my lords, I can just request my lords to issue notice in our IA. I understand that pleadings in their IA are complete. So my lords, we don't even need pleadings to be complete, but just so that we can argue on the 2021 application, my lords can just take note of our intervention application number.
What do you say? Does anyone have any objection to her?
So they'll assist
I
the
think
court. They
first-
can always assist the court.
She can always assist the court. My request to your lordship, let the matter come up, and at that time, whatever request is made, your
We
lordship
will
will
bear
consider
that
it.
in mind. We'll give you
Yes, yes.
notice.
My lords, we just note
Yes, all the parties, I mean,
Yeah.
intervene so that
There's no issue.
not impeding.
Yes, yes.
No,
Some kind of personal.
fair enough, fair enough.
So there are two dates that I find. Let's read the calendar. I think 10th and 17th of January are Tuesdays.
10th of January.
17th.
Yeah, whichever date which your lordship for
17th.
final disposal.
Why 10th of January is inconvenient?
Well, there'll be a lot of miscellaneous.
There'll be a lot of holidays, bro.
Holidays
That
in
sometimes
which
there'll be a lot of holidays.
That's why I said.
All right,
I
17th,
don't mind 10th.
17th January.
Come.
Yeah, Pongal.
Yes,
on that day, it's understood.
Yes, it'll be for final disposal.
It is for final disposal.
And your lordship may indicate some date, say a week
The
before.
first week would
Where
be a
short
miscellaneous.
notes of submissions can be filed.
But who will actually, all these constitution-based matters, we would like to have a common convenience
That we'll do, Manoj.
so that you'll have to get together and put it together. So
No, we'll ask Brinda to take it up.
Huh?
We'll coordinate
But,
with
with Mr. Kanu Agarwal and Brinda.
Somebody from the,
Lordship may note, you have to record Kanu Agarwal and Brinda Bhandari will coordinate to make a convenience.
that's right.
Lordship
Send
will
the
be-
documents
It
and then
needs
they
to be
can
completed
compile.
by matter. So reply has been filed. In the
In all matters, they have to complete whatever.
Yes.
matter-
I don't know. His thing is that he wants all the data to be localized in India.
Whatever, Manoj, pleadings to be completed by end December,
We will insist that briefing should be completed
by 15 December.
15 December,
Yes.
exactly.
Before the vacation.
We will
Yeah,
have
so
a
1 month.
clear idea.
Yes, yes.
And then somebody will actually put together a
Yes.
common
We'll do
convenience
that.
audio.
We'll do that.
So we don't have to look to many volumes.
Reflecting all views, Manoj, so that pagination is
Who
continuing.
will undertake that task?
My
So
lord,
that's Kanu Agarwal and Brinda Bhandari.
Kanu.
Huh?
I'll do it with Mr. Agarwal.
Just give the name of.
Kanu Agarwal, my lord, Kanu.
Having heard, no, first of all, so when this matter came up, started, Solicitor General. Submitted a matter came up suddenly, was yesterday night. It's pointed out this is a case where Parliament had introduced the bill initially, but for good reasons it was withdrawn. It is further is sufficient that the stand of the government of India is
There was a draft. It was
It's not introduced, Manoj, if I remember correctly.
It was.
It
It was
was
introduced.
Went to a
It
parliamentary
was
committee.
introduced in December
But
2019.
I'm not aware, so it may not be possible for me to make an accurate
Look,
statement.
my lord, it was introduced in December 2019. It got referred to the joint parliamentary.
If my learned friend says it must be.
It was
We have
tabled.
I'm relying
We have
upon
the
my lord, the
withdrawal.
last
It
interview.
was tabled, it went to the parliamentary standing committee, then it was not introduced formally.
introduced. So it was tabled.
Tabled. Manoj.
Tabled it.
And the bill was tabled.
And withdrawn.
Bracket, you may just say.
Later withdrawn.
Council for WhatsApp.
That's correct.
Your Lordship may say
Correct it by pointing out that though tabled and referred to the committee, it was not
Formally
introduced as
It was
bracket
subsequently withdrawn.
process.
And then subsequently withdrawn.
Withdrawn. Not, it was it called the
The
first.
bill was withdrawn.
Yeah.
It was called the.
However, the other solicitor would point out that Parliament is mulling, bringing in a new law which should address the concerns of the parties. It is its definite stand that the policy of the government of India is that the users of WhatsApp and other platforms in India should not suffer discrimination in comparison to the users of these platforms anywhere else in the world.
Lordship may not say
Did
that
not say
because.
that.
We are saying it because we are not putting it into
No,
that.
that's
We
why.
are
No, no.
putting it
Yes.
into-
Yes, please.
No, no, I'm not, that is my.
No, please record it.
No, Lordship.
Record it because that is his standard. That's why you are not going to be affected.
But why say WhatsApp, Manoj? Just say all the users, Manoj.
Media.
Just
So then
All
your Lordship said that
intermediaries.
WhatsApp, you
all
know, why?
intermediary.
All interviews.
So otherwise,
I don't
Manoj,
say what-
it has
all
also,
intermediaries. All intermediaries. All
No,
intermediaries.
as far as European Union are concerned, 27 countries
Don't
have
worry,
different
that-
platforms.
Don't worry, nothing is going to happen.
Out of 213 nations, only
You can
27.
continue to do merrily what you're doing. Nobody is stopping you in the meantime. Okay. Sri Shyam Diwan, our senior counsel for, you are appearing for the petition.
Yes.
So the petitioner would submit that, while it may be all right, if some time is granted for the Union of India in its decision to introduce a law and make a law, the matter being adjourned, it should be on the understanding that when it is listed on the next occasion, it will be taken up a final hearing unless it be the impact of the legislation overwhelms the issues which are covers every issue which falls for consideration in this case. But we are inclined to adjourn this matter, taking note of the submission made by the Running Solicitor General to the 17th of January. This is case on the 17th of January for final hearing. By the 15th of December 2022, pleadings in all these cases shall be complete.
My lord's family request, we have an IA 11372, which is impugning the current 2021 policy direction. My lord, we issue notice on that so that the pleadings can get
Not
completed.
WhatsApp centric. I don't know why.
But I think, no, this is again,
Allowed
all these things you can argue.
No, intervention is allowed.
Allowed.
This is a application for directions, my lord. Just
To what direction for what?
my lord, which is on the 2021
It's against
policy.
it's
WhatsApp.
only against WhatsApp. It's only against WhatsApp's new privacy
That's right.
policy.
What do you want? You want
It's
them to
notice to be issued.
Not by virtue of an application, they want to challenge the new policy.
I don't understand.
My lords will see the last order. My lords will see the last order of 15th February
don't think you
2021, my
should
lord.
be doing that.
My lord, by virtue of an SLP, the new policy is being challenged in SLP. I mean, that only can't be done.
So, I mean, what is going to be the effect
legal
of
issues
not
will be
passing that order?
Okay, my lord.
It's going to be a legal issue finally.
That's
It's
right.
it's not going to go on facts as such.
That's right.
And there we will have the assistance of Sham.
Pleadings would not be of much relevance.
No, wherever pleadings have to be completed.
It will have to be, but-
We are giving you ample time. But on that day, if it is not there, I mean,
Yes, yes.
nothing concrete doesn't have to be proceed to the hearing.
Yes,
You
yes.
understand? So and so, just take the name.
Mr. Kanu Agarwal and Mr. Prabhas Bajaj will provide that
Will
convenience.
provide that common convenience volume containing
Documents relied upon by
documents relied upon-
respective parties.
The documents relied upon and also the contentions of all the parties.
No, but that's documents, no, that's just compilation will be documents and then,
It's only the document.
yeah, only the
Only
documents.
the document. All right. Only the document.
Common compilation of documents
Common
on
compilation of documents.
or before 10th of January.
But let's kindly add the name of Shashank Mishra from our side on the
Yes, certainly.
convenience
That's
compilation.
fine.
Yes.
So we're three of us, but it's just not Kanu Agarwal, but Shashank Mishra as well as Vrindavan.
You can begin by completely owning up the financial aspect of it. So,
No problem at all.
so and so will put together.
Shashank Mishra.
Common compilation containing all the documents relied upon by all the parties before the 10th of January 2023. Okay?
Yeah.
That's
Deeply obliged.
And if you would like a short note of submissions on or before 10th of January by the respective party. If you would like a written note, not necessarily we'll.
not necessary.
That's in both
Grateful,
cases,
thank you.
the corrected matter. Corrected matter also.
Looking at the face of the lawyers, I got a bit confused. Who is the face of amongst Dr. Sibal, Rogi?
Well, it's all of us
Who is the
together.
face of Facebook?
No, all of us together. All of us together.
But we have our leader in Mr. Sybil, but we are all there to assist your lordship. Lordship not making like a Ravan with 10
You
faces.
are not replying to Janet's question. Who is the face amongst all?
Grateful.
Yes.
Lordship not making like a Ravan with 10 faces.
You are not replying to Janet's question. Who is the face amongst all?
The appointment of the election commission. Today, my lord, it's only the prime minister who decides. We are saying that in
Should not be
accordance
like a
with
Ravan
the
with 10
reports
You are
of
not
a very
replying to
simple
Janet's
shortened and
Who is the
committee
face amongst all?
appointed by the government. The appointment of the election should not be. Today, my lord, it's only the prime minister who decides to be a neutral body. We are saying that the selection
Should not be like a Ravan with 10 faces.
You are not replying to Who is the face amongst all?
by the government. That same kind of committee of the election should select the, today, my lord, the government, the prime minister will be supposed to be a neutral body. We are saying that the selection of
Should not be like a Ravan with 10 faces.
You are not replying to Who is the face amongst all?
by the government. That same kind of committee of the election should select the, today, my lord, the government, the prime minister will be a number of reports of several commissions which have recommended for
Should not be like a Ravan with 10 faces.
You are not replying to Who is the face amongst all?
by the government. Merely says same kind of selection election should select the same like government, the prime minister will be a number of reports of several commissions which have recommended for
Should not be like a Ravan with 10 faces.
Let's not argue about this hearing.
merely says same kind of solution directly deals and track
Vegetarian.
It is under section 63 and section 45. It is under section 63 and section
45. These three sections
Thank you.
Thank you.
motivation in this and there is that society normally motivation in this and there is that society normally motivation in and there is
divorce based on cause. I'm sure that we may not be able to, I may not be able, perhaps I won't be able to persuade you that you should also take a statement. Because that is, at the end of the day, that judicial body looking into it. But here what they've done in England is, they've said no, either or both parties favor.
It's taken them so many years to come to this stage. Yeah, also it will take time.
I was myself surprised, Lord, because of this confusion in the head, fault and no fault are the same, but they're
The
stage where you say
distinction
purport.
is obliterated there. But,
Yes, I'm surprised. In between the amendments, but this is the latest amendment now. It is generally believed that changes made in 2022 depart. However, it is submitted that irretrievable breakdown cases mentioned in the original Act of 1973. It is worth noting that irretrievable breakdown of marriage is the consequence of pre-existing causes. That is why, my lord, in the when this court said there was seen as many of which would include adultery, desertion, cruelty, or separation of a continuous period. In other words, I'm saying, well, these are not exhaustive of the issue of it may be noted that the UK Matrimonial Causes Act engaged very clearly that irretrievable breakdown of marriage and breakdown on account of group are interchangeable, and that these are factors to breakdown of marriage and irretrievable. Hence, a decree for irretrievable breakdown of marriage can be granted in the above circumstances as seen to exist in the marriage. Period of separation, this is my suggestion, the period of separation will include the period. And it was pointed out to me by this court that in the UK they say the period has to exist prior to the filing of proceedings. But my suggestion is, my lord, the pendency of courts having regard to the enormous delays should also be taken into consideration. Another very common indicator of breakdown of marriage is initiated proceedings under 498A if they need to go to either party libel, defamation against each other, other criminal proceedings for cheating, all of which lead to the conclusion that the marriage is broken down. All these indicators have been drawn from judgments of this court. Then, when I deal with the fault theory, it is true that some of the statutes in divorce contain provisions to the effect that it is to be satisfied that the party is not taking advantage of their own wrong. In section 23(1), it is submitted that the context of the husband either wanting a decree for restitution to defeat a claim of maintenance. In such a situation, it may be useful to look into the question whether the husband is taking advantage of his own wrong. However, in a hotly contested matter, seeking divorce on the ground of cruelty, desertion, adultery allegations are often made. This honorable court has held that by all this, and not an interesting observation. Give me Gura versus Gura. Interesting observation, my lord. Deciding to grant or not answers the question posed to me. Decree on the ground of breakdown of marriage not be blown out of proportion for in isolation and granting a decree for the cause of the ground of breakdown of marriage. Now, my lord, that judgment can be found at page 63 of. It is the only judgment, my lord, that I found which could aid in the interpretation of section 23. Again, this, but I won't take you through the facts because there were again multiple the allegations you will find at internal page 68. I mean, the allegations and counter allegations that they were having pornographic relationships with other people. Then, my lord, para 9 criminal proceedings were filed.
so then his consent was filed, withdrawn after that. Consent withdrawn in the window.
Yes, multiple petitions for divorce were filed. And then the indicators are at page 75, para 19. While considering the matter in detail, we find that the court had not disputed the following. Marriage parties dead and broken down. There were allegations and counter allegations between them. Also sorts. And love is lost between them. There is a delay in the disposal of the matter. The husband has married again and has got a child. The wife has not withdrawn her consent lawfully given for a period of 18 months. The joint petition filed in the court by the parties have settled the matter, and the wife has renounced her right to claim maintenance, which the parties prayed for was only a decree for designation of marriage by mutual consent. It appears that the appellate court was not come to court with clean hands. In that he married during the pendency of the proceedings. It may be, as expressed by the appellate court, that the factors such as marriage is dead and has broken down irretrievably, that there was no chance of reunion, that there were allegations and counter allegations made by the parties, and the parties were residing for 13 years. Each one of the above factors by itself individually may not have photographed. This is another legal formula that they use. Each one is not sufficient, but cumulatively they are sufficient. Here is the view that the cumulative effect of various aspects of the case in dispute found that the marriage is dead, both emotionally and practically, and there is no chance at all of the same to survive. And a continuation of such relationship is only for namesake, and that no love is lost between the parties who have been fighting like Kilkenny cats. And there is a long just that, yeah, that on the interpretation of 23, I would recommend para 23. Okay. Para 23. We cannot do, and we have not lost sight of the fact that the conduct of the husband is blameworthy in that he married a second time and got a child but that factor cannot be blown out of proportion. Similar, that answers, I hope, the question about section 23 that was posed to me. Then what do we do? We find that the party asking for divorce is at fault. Then, my lord, it is also important that before a decree is granted, an attempt should be made to reconcile. In view of the foregoing, the answers framed by this honorable court, as quoted here and above, may kindly be answered accordingly. How it is submitted that before such a decree for divorce is granted on account of irretrievable breakdown of marriage, certain safeguards for the parties to the marriage, in particular the wife, are needed to be put in place. Sure, by this honorable court. But a final attempt is made in reconciling. The determination is made that the marriage has been broken down. Adequate financial provision, more particularly which is just, fair, and equitable. Having regard, I will not please note that I've used the word equitable. Having regard to the various factors such as housing arrangements so the divorced wife and children, if any financial arrangements consistent with the standard of living to which the husband is accustomed, welfare of the children, including the housing, educational provision, marriage, medical expenses, entertainment, extracurricular activities, custody of children where such custody is not mutually agreed in the best interest of the child. And no, this is the last one I've added based on Bhagat versus Bhagat. No blame is attributed to either party as a result of the decree for divorce, which may impact future civil or criminal proceedings. Now, my lord, this is just a checklist. Now, obviously, each one of them in the matrimonial law of other countries is very highly evolved, where the statute itself deals with financial provision. And I must point out, my lord, I'll be failing in my duty if I don't point out that England does have a regime of equitable distribution of matrimonial property on the breakdown of a marriage. We don't have it. More the reason why we should be careful in putting these safeguards in place while granting such a decree. A lot of attention will have to be paid to the fact by the judges that, Lord, now there are judgments of this court and of the Delhi High Court which cast the burden on the husband to disclose his financial status. And if I may say so, my lord, in the days when black money was very common, it was impossible for a woman to prove what is the real worth of her husband. There is so much hidden wealth in this country, it's unbelievable. But my lord, my information is that after demonetization, it has gone down a little bit. The existence of untaxed money, but how much
technology and methodology today are available to get indexes will give us a better assessment of the income of the household. Maybe returns, income tax returns, it may be other assets, ability to value those assets. Anything else?
Not only one thing remains. I am keen on your lordships accepting the proposition that the right to marry and the concomitant analogous right to not to exit a marriage is a fundamental right. I would put it squarely under the right to life and liberty, read with the right to form associations. But at the end of the day, a marriage is an association. It is it is the right to affiliate.
One's fundamental rights are subject to reasonable restrictions.
It is, Lord.
It's
going to be,
principle is
whether you like it or not, it's going to be a very major issue which is going to surface in this country. In a multiplicity of situations. Not that I'm arguing proxy for anything, but I need to let you know that there are petitions pending in the court where gay people have said we also have the right to marry because it's the right to affiliate. What the court will decide is not for me to say. But this is well traversed ground.
Can we step into those domains in these proceedings? Would be difficult to. I may have my own views in it, but I can step into those domains is a little difficult because then it would be really foreclosing the opportunity in those cases of this issue being debated. And
no, I am more interested in saying that right to divorce is a fundamental right. I am not asking you to address for the purposes of this case. For the purposes of this case, my lord, what we are looking at is there a right to divorce? What is the nature of that right?
See, there is no doubt there is a right to divorce. There is no doubt there is an enactment now for right to divorce in every position. Question is where there is a cause, and the cause may be by one person, or both persons or other person. As long as people cannot live together, you are saying that they must have an opportunity to part ways and live their life.
Look, like all laws, it has to pass the test of reasonable restriction. If it's a fundamental right, then like all laws, it must pass the test of reason. If you unreasonably keep two people in a bad marriage, then, my lord, I'm sorry, the law is liable to be declared bad in law. That is why it's important to understand what exactly are we dealing with. We are dealing with intimate relationships. An intimate relationship, no decree of the court can force an intimate relationship. That I'm only arguing that you must keep that in mind. But lord, I've got a few additional submissions. I'll finish quickly before we close for lunch. But they're already in writing. I've given a volume, and I won't take you through the literature on the subject, but there is literature. And the primary additional submission, just tell us, and those additions. The primary one is, Lord, I'm just adding one more submission, and that is the right to marry a person of your choice is a fundamental right and guaranteed under 19(1)(c), read with Article 21. Equally, is the right to divorce must be considered a fundamental right, and no unreasonable restrictions can be put on it. It is submitted that the right should be protected under 19(1)(c). It is submitted that the right of association includes two rights: the right to form expressive associations such as unions, and the right to form intimate associations such as marriage and familial bonds. Then, there is this judgment of the Supreme Court in Roberts, which was a very interesting judgment. A club said we'll keep out women. And the law that was passed said that you can't keep out women. And in that case, my lord, they distinguished between intimate relationships and non-intimate relationships. So they said, all right, we can force somebody to become, to take a woman as a member in a club, because it's not an intimate association. But intimate associations stand on a different level. So only for that distinction between the two associations, my lord, the case is known as Roberts. It's there in the compilation.
Yes, you've given it a note on it in para 2 of your editions.
Para 2.
You already incorporated it.
That is belonged on the well-traveled ground, well-traversed ground by this court on Puttaswamy. I'm sorry. Yes, Malone, there that the summary of Roberts submitted the United States Supreme Court in Roberts where the constitutional validity of public accommodation laws was under challenge, held that the guarantee in the 14th Amendment of the United States Constitution protected, among other things, the right to marriage, childbirth, cohabitation, and with one's relatives. Such a right would also entail the freedom to leave such intimate association. This, I suppose, is my submission. This submitted that the right to form intimate association is a part of the freedom of association at 91C of the Constitution of India. The right to enter into association has an analogous right to leave in such an association without state interference. Now, my lord, this should be modified without, there is state interference in the form of the judge, the judiciary. So therefore, my lord, I would modify it and say reasonable restrictions can be imposed on the right, but not unreasonable restrictions. And to deny a divorce on the ground of irretrievable breakdown would amount to an unreasonable restriction than the right to leave a bad marriage. Then, my lord, your lordship may go through Roberts, the full text. I point that in this volume is also literature about how bad marriages impact children. That your lordship will find
Yes.
page 30, at page 31,
Conflict and then amenity.
and how bad marriages are also bad for the two parties in question. There is an article on that as well. I mean, to me, it's common sense, but then academics want research, and that's why I'm giving you the research.
Thank you.
My lord, I am here in my capacity as amicus, and therefore I can only persuade you. Beyond that, my lord, there's nothing I can do because I'm not representing a client.
Doesn't make a difference.
But
You are still persuasive enough.
I have to say that your lordship have given me the liberty to express my point of view, but in my capacity as amicus.
Thank you.
Well, no, there's no judgment of this court, incidentally, on what is the goal of an amicus. I haven't seen it. I've been looking for it high and low.
In one sentence to make us write better. Mr. Giri, you will begin at 2 o'clock?
Yes.
Obliged, my lord, for the patient.
After Mr. Giri finishes, I'll take about 45 minutes.
Okay. How much time will you take?
Not more than 40 minutes.
Let's try to wind up today. Because
I'll convince myself.
I've scheduled other constitution benches immediately after reopening. So I would like to, I anticipated only about kept 1 day's cushion.
Read for the judgments, my lord, for the compiling.
Give us some time also.
On what? See, divide your time. Both are saying. Ultimately, it will be repetition otherwise.
Correct, we'll not repeat.
All of you seem to be, I've not had a different point of view. All of you seem to be on this basis that in different ways, please exercise this power.
Yes.
But I am going to be
Opposite.
submitting to the country.
Oh.
Cannot exercise.
Oh, I'm glad my learned friend mentioned that.
No, it's at least that somebody puts a different point of view. Somebody has to put a different point of view, so we have the satisfaction of.
Definitely, because the way 142 has been used by this court, it's matter of
No,
concern.
the loose copy.
From income tax, for all kinds of matters, 142 is now being exercised. And that's a matter of great concern.
Probably on the argument about fundamental right to association and then fundamental right to get divorced, we may not be agreeable with the submission, But on the question framed, we would argue that yes, it can be exercised, it can be molded, it can be ready to the enactment. Will be our submission.
If Mr. Dave,
I try to wind up, my lord, in 30, 35
if
minutes.
you can wind up in 30,
I'll just
35
make the
minutes.
points
And
for-
similarly, Mr. Dave, if you can make an endeavor to conclude.
Next.
I won't take.
I'm trying to persuade you to take 10 minutes less so that the others get it done.
I should have mentioned, just give me 2 minutes, delay your lunch by just 2 seconds. At 2019, page 1, just make a note of the judge. It is a case where the issue was whether voice sampling can be done.
Yes.
And one of the arguments was that this would go against the right to self-incrimination. The court rejected it. But what is important in support of my argument that it can be done under 151 is this court actually said we can give this power to the court, to the magistrate court, para 22. That was done. So far as the second basis of the view taken is concerned, we have already expressed our opinion that what may appear to be legislative inaction, very important, not in the light of Mr. Dave's submission. To find, no, because he's. I know you are, yes, and I'm glad there's a contrary point of view because I can counter it. Well, I said, because I'm not holding a.
Just give a look.
Yeah, let's speak.
Serious inroad on Article 20. And it's completely contrary.
Okay, thank you.
My lord, I can tell you many judges in this court, but their judgments are poor.
You're not depriving us for lunch.
You don't tell me what to rely on, okay? What to rely on and what not to rely on. It's not your remit in this court.
Something apart from depriving us of earlier lunch, I have a meeting also of some concern to lawyers. We will sort out that problem.
So, just, my lord, your lordship will look at this judgment where there's an interesting discussion on whether this is legislation or not legislation.
We will read through the interesting.
Yes,
Thank you.
please do because it can be done.
Thank you.
Minister Jaishankar, thank you very much. Day 2 of your trip to the CEE. It's been quite a ride since February for not just the region, not just Europe, not just the West, but it is now trickling in terms of effect of what's happening between Russia and Ukraine into the rest of the world, the East, the global South. Paint us a little bit of a picture of India and how India has been impacted. You've come out of COVID. You've had issues on the border with China. You've come out of the Quad with many, many diverse and divergent opinions, and an economy that is looking to make dramatic changes, but in very difficult and turbulent times. So if you can paint us a picture of where India is at right now, and then we will pick up the conversation from there.
Okay, let me go with exactly that flow. I think, yes, we are largely out of the COVID, though it never quite goes away. But we are out of the COVID also with a strong sense of economic recovery. I think there's a lot of optimism about rebuilding, and not just rebuilding, but actually leapfrogging in many areas, particularly digital. I think we handled it very prudently. I almost am tempted to say smartly in terms of the financial responses, which was we didn't blow the bank in responding. We intervened where we had to, and very effectively. At the moment, in a sense, the Modi government has just completed 8 years in office, and what we have done in those 8 years is really to, I would say, build almost I would say, a social welfare society at a speed and a scale which the world hasn't seen. And in some ways, the COVID has actually hastened that. I mean, we are, for example, as an example, we are giving food support to 800 million people, and we've been doing this for more than 2 years. So that's like the population of the US and EU put together. We have a house ownership, publicly supported house ownership program, which covers about 115 million beneficiaries, which is almost like building houses for Japan. Or even if you look at terms of, this campaign, this program actually to replace firewood with gas cooking, it's impacted 80 million people. That's like changing Germany's kitchen in the space of a few years. So there's a lot going on there. And why I mention that is many of the global developments today have the potential of actually putting that under stress. Your second reference was to China. Yes, we are going through a particularly difficult patch in our relationship with China. We've had differences in the past, but we've never had a situation where, after 1962, where really agreements on not bringing forces to the border have been disregarded. A very large number of forces have been brought to the border. We've had a clash. People have died. And this has not happened now. It happened 2 years ago. So in a sense, it's a bit of a diversion, but it's also a useful reminder to Europe that there were other things happening in the rest of the world, which sometimes Europe perhaps doesn't pay enough attention to. There's also been Afghanistan, and what happened there, the circumstances in which the Western, particularly American military forces left finally. And now we have Ukraine, and coming into this region, it's a region which I know well. I have lived here in Budapest and in Prague. It's a region which has been very helpful to us when we wanted to get 20,000 students out of Ukraine. Slovakia, Hungary, Poland, Romania, even Moldova. But I think it's also important for people in the region to realize how this is playing out in the rest of the world, that it is creating a huge fuel crisis, a food crisis, a fertilizer crisis, pushing inflation in low-income societies which don't have the margins really to absorb that. And so it can very quickly become political in many societies.
I think that brings up an interesting question that's come in from an online audience member, which is relevant to this, this point that you make about the rest of the world versus right here, right now in Europe or in the West. How interested are the Indian people in the war in Ukraine? Is it a major concern? Is it a minor concern? And you've kind of alluded to the fact that it's affecting fuel, it's affecting food, but how interested is the populace itself?
I think it's a major concern. It's a major concern for two reasons. Look, today our existence is very connected. I mean, everybody sees things on the television, on their phones, on the net. So wherever you are, and because bear in mind today India is a very digital society. Even people at lower levels of income, the one thing they do have is the connectivity. So there is a lot of awareness. I don't think anybody, everybody is, to put it mildly, disturbed at the conflict. They see the pictures, they see that happening. But the other part of it is it has begun to impact people's daily lives. That it's impacting the petrol cost at the bank. It is